SJC-12313, Commonwealth v. Jonell M. Brown.
Mr. Russell, good morning.
Good morning, Chief Justice Gantz, Your Honors, and may it please the Court. Luke Roseal, appearing on behalf of the defendant appellant John L. Brown. In my argument today, I'm going to try and cover three different points. First, the allocution and the double jeopardy error, then the ineffective assistance of counsel before and during trial, and finally the involuntary waiver by Ms. Brown of her right to testify. Before getting into those points, I want to make just a couple of remarks about the 16L letter I sent in under Com v. Muckle, the very recent case. This court made clear in Muckle that the distinctions among the different categories of potential victims under the felony witness intimidation statute are relevant for district court jurisdictional purposes. And one of those relevant distinctions is the distinction between a potential witness and a witness. Here, the alleged victim at the time the crime was alleged to have been committed could only be described as a potential witness because, at the very least, there was no proceeding in effect for her to be a witness in. In fact, I'd argue that really, before a person can be considered a witness, they should be sworn to give testimony. That's what distinguishes a potential witness from a witness. Otherwise, that statutory distinction cannot be given much meaning, as it ought to be. Getting into the briefed issues, the first area of error that I want to try and cover is the allocution error. After she was convicted, but before she was sentenced, Ms. Brown should have been afforded a reasonable opportunity to personally address the sentencing court on the natures and circumstances of the offense, even if her remarks were not entirely consonant with the trial testimony.
Didn't she end up getting what she asked for a sentence?
Certainly, Your Honor, and I think that, Justice Budd, that goes to the question of whether, in a vacuum, the allocution error would afford Ms. Brown to any relief in and of itself. I don't think that there is a meaningful form of relief that would be addressed only to the allocution error. I think the allocution error was really part of how the court ended up violating her double jeopardy rights.
If we could step back, is it your claim that the right of allocution, well, is it your claim that there is a constitutional right of allocution?
That's correct, Chief Justice Gantz. And under McGartha, 1971, at least the Supreme Court assumed without deciding that there's some due process right to personal allocution. And the Mass Appeals Court case, Curry, that holds otherwise, cites to three cases that don't support that holding. At the very least, a federal defendant, by virtue of the procedural rule, gets a personal right of allocution, but our procedural rule doesn't have that language. And I think it's strange, at least, that the reporter's notes to our procedural rule quote at some length from Justice Frankfurter's dissent in the Green case, where he wrote for himself and three other justices about how important allocution is. The reporter's notes in the procedural rule speak to how it can help both in terms of mitigation and it can have therapeutic value. And the judges who have been surveyed or have written about this topic tend to agree uniformly that personal allocution is important. And here Ms. Brown was afforded 35 seconds. As soon as she said that the alleged victim had not told her that the restaurant was closed, she was cut off with the remark, quote, "I'm not going to hear your side," end quote. And it was from that the double jeopardy violation sprang. And so the point...
But, I mean, assume there is a right of allocution for the moment. It's not a right of allocution to retry the case. I mean,
Certainly.
I mean, at some point, could you have not said that, could the judge not have said that you are abusing that particular right? You're also foolishly undercutting your attorney's arguments. I mean, as far as I can tell, the judge essentially called a timeout because she was making it harder for the judge to do what her attorney wanted her to do, and which she ultimately did. But if there is a right of allocution, is there not the ability of a judge to limit its scope to focus on mitigation of punishment as opposed to claiming that I was innocent and I'm now going to testify where I did not testify before?
Certainly. Two things on that, Chief Justice Gantz. First, yes, I think the sentencing court would have very broad discretion to limit it. But 30 seconds, and the only comment that was not consonant with the trial testimony, she did not claim innocence. All she said was, they didn't ask me to leave the restaurant, they didn't tell me it was closed. I think that exceeds the scope of discretion that a sentencing court should be afforded to cut short a defendant's personal allocution.
Can you explain to me, please, the historical basis for the right of allocution?
Originally, it's my understanding that on certain capital offenses, the accused was not allowed any cross-examination, not allowed to testify at all, and so it was really the only time at which the accused was afforded the opportunity to address himself or herself to the court. Of course, it's a different import that it takes on in our modern system with the procedural protections that we do have, but where it is protected on the federal level, where judges tend uniformly to agree that it's important in terms not only of mitigation, but also it has some therapeutic value, and where our reporter's notes in the procedural rule tend to indicate its importance as well, I'd argue that it should be upheld here in Massachusetts as a constitutional right.
So I'm having a hard time getting to your remedy.
Certainly, and
So let me just play back for a moment. I understand that it is concerning when your client came back to court after she was held, that the judge made a comment about getting her attention. It is concerning. And maybe it was a little bit quick to cut her off as soon as she started to contest from the judge's perspective, the jury's factual findings. But giving you that, which I'm trying to state in the most favorable way to your client, how do you get to the remedy you're asking for?
it's the Hudson case, Your Honor, where it says if the record admits of the clearest proof that the purportedly non-punitive bail revocation was actually punishment, then it triggers the double jeopardy protections. And here that clearest proof comes in the manner that the bail revocation was conducted so quickly and without consideration. But also I want to stress no adherence to the bail statute's requirements. The bail statute by its terms applies after conviction but before sentencing because one of the factors to be considered is whether the defendant is pending sentence on, quote, any conviction. So by its own terms it would apply. So at the sentencing hearing, if the trial court were to incarcerate Ms. Brown, there were two types of authority available: imposing the formal sentence or revoking bail in accordance with the bail statute. And it's very important that the statute be made to apply in this area because otherwise trial courts would have unfettered rule-based discretion under Rule 28, which says the defendant should only be held in accordance with law, and of course the law here is the bail statute, to hold the defendant as a means of, quote, getting their attention. There's one other thing that I did want to...
I'm confused a little bit.
Certainly.
Rule 28 provides that pending sentence, the court may commit the defendant, right?
And I believe there's a proviso at the end of that provision indicating in accordance with law. And so here they can be committed either in accordance with the law that authorizes the judge to impose a formal sentence or the law that authorizes the judge to revoke bail if that's the only means that's up to the job of reasonably assuring reappearance and safety in the community. Those are the two sources of legal authority to incarcerate the defendant.
So you're saying that if a judge says the conviction has occurred on Thursday and we're going to hold a sentencing hearing the next day, and I want to carefully consider all that's said, maybe even get a pre-sentence investigative report, that the judge can only hold the person if they make the findings that would be the same findings as if he had committed another crime while on bail?
It would be the same findings, yes, under the bail statute. Otherwise, there is the only legal authority the Commonwealth points to here to authorize such a commitment is Rule 28 itself. And the Rule 28 says you can commit them as provided by law. And the one distinction I want to try to draw very clearly here is Ms. Brown was never sentenced to 1 day of incarcerated time. Her sentence did not authorize the Commonwealth to incarcerate her for even a single day.
So if the judge had sentenced her to 4 days, time served, in this case, rather than probation?
I think I'd have a harder time making the argument that this record admits of the clearest proof that the prior revocation of bail was a separate and distinct punishment. But when we look to the factors under Hudson, whether there's a restriction on liberty, there is with the incarceration, whether it's historically punitive, incarceration is, whether there's an element of scientur and whether the underlying conduct was criminal. There was, with the intimidation conviction, there was an element of intent. And so the only remedy that's up to the job here is vacatur of that formal sentence that violated Ms. Brown's right to double jeopardy by again punishing her separately and distinctly apart from the bail revocation, and an order prohibiting retrial, otherwise Ms. Brown would be susceptible to being jeopardized yet again.
You know, in the district court, sometimes the trial's over, it's in the afternoon, and the judge, I think prudently, might not want to sentence that day. It's oftentimes a good idea to wait until sentencing for a day or maybe even a little longer. And you get some information, you have a hearing, and after that hearing and some serious thought, the judge decides that incarceration is not necessary. Does that mean that if there's a probation revocation, that you're going to say that there was double jeopardy because the person was held?
Only if the probation revocation was conducted without resort to the procedures and the substantive factors dictated by the bail statute.
But I'm sorry, what I'm saying is the judge held the defendant for a couple days before sentencing, in my scenario.
Yes.
And then decides to impose probation, but they've been held, and they get a probationary sentence. If later on there's a probation revocation, does that mean double jeopardy?
Not if the judge who held the defendant pending sentencing did so in accordance with the bail statute.
Maybe somebody's ever done that. I don't know that anybody ever has.
And maybe it's a wider problem or a wider instance of exercising authority than might be borne out, but the underlying point is the legislature might have the authority to authorize judges to hold defendants in circumstances that Justice Lowy, you're describing. But here, the way the law is now, either they've got to revoke bail in accordance with the bail statute or sentence the defendant. Otherwise, there's this limbo where there's really unfettered discretion to hold the defendant to get their attention.
Counsel, do you think there's a possibility that you could create an unintended consequence of pushing judges to sentence faster or more without enough information?
Perhaps, but by
That would be tolerable?
I think that's more tolerable, than having this form of or incarceration authority that does not have any basis in statute or otherwise.
Well, I mean,
If I may, I'd like...
Looking back to my days as Superior Court judge, so person's convicted of a crime. It's a crime in which I have the authority to sentence. Since I could that day sentence the person to some time, why can't I, as I often did, revoke bail and say we're going to postpone the hearing for either for a cooling off period or to let the chance for the victim to be present, to give a victim witness statement or to do a pre-sentence investigative report. If I have the authority to sentence that person to jail, why don't I have the authority to revoke bail pending sentence?
I think the sentencing court does have that authority so long as it adheres to the bail statute. I mean, that's the underlying rub. The sentencing court has that authority by virtue of the bail statute. And so when there's no adherence to the bail statute, when it's done as a means of getting the defendant's attention, when it's on the heels of an allocution being cut off abruptly after 30 seconds, that's the clearest proof that that's a punitive bail revocation.
Is there a bail review available in the Superior Court if it's in the District Court, BMC, or Juvenile Court?
That could be one remedy, Your Honor, but that remedy wasn't pursued here. That was well before I was involved in the
I
case.
didn't mean it as a good thing.
No.
I meant it that you're now going to have District Court judges revoking bail to give them a couple days to let the waters settle, and the Superior Court judge in first session is going to be doing a bail review on that when they don't know anything about the trial?
I think there's a low likelihood of that, where there would only be a couple days. But I see the theoretic possibility, and again, I think my underlying point that I keep coming back to is it's got to be done in accordance with law. I do want to make just a couple remarks on the ineffective assistance of counsel
Can I
arguments,
ask
if I may.
one last question?
Certainly.
If we don't accept your double jeopardy penalty, and we also think there's more flexibility here, but we agree with you that the judge should not have said, I got your attention now, meaning there's sort of a punitive aspect to what she did. Is there another remedy out there, a lesser remedy, if we don't buy your double jeopardy argument?
I have racked my brain, Justice Kafka. I've done a couple different moot court arguments, and that's been one topic of discussion. I cannot come up with another remedy that would be at all meaningful to Ms. Brown in the circumstances of this case. And I understand it's strong medicine, to use that expression. Mm-hmm. If I may move on just very briefly, the 2 points I want to try to make on ineffective assistance. First, there is no evidence on this record to support the Commonwealth's contention that the third-party recipient witness, Mr. Carr, whose affidavit is in the appendix, is the unidentified assailant at the scene. No, it was Tyrell Carr is the gentleman's name. And he attests in his affidavit to being there on the scene. He accounts for all of his movements, and he's not at all involved in this separate fight. He sees Miss Brown struggle with the debit card. And the case I want to bring up here is the Hampton case, which I regret is not in the papers. It's 88 Mass App Court 162. There, the trial counsel forewent interviewing a precipient witness. The Commonwealth said it would have done you no good because he didn't see anything of import. The trial judge agreed and denied relief, and the appeals court reversed, saying that credibility was not an issue for the trial court, but because it would have supported the defense, it should go through. May I make one other remark with regard to this argument?
Briefly.
In all of the other ineffective assistance cases where relief was granted, that's Hampton, Caban, Farley, Duran, the defense that was being pursued at least made its way to the jury. Here, counsel's performance was so subpar that the defense of property defense was precluded altogether. And Ms. Brown had no way of knowing in waiving her right to testify that that would be a consequence of her doing so. He promised defense of property in the opening. It never materialized, and that's ineffective assistance of counsel calling for reversal of the judgment and the sentence on the convictions that entered below. Thank you, Your Honors.
Ms. Johnson, good morning.
Good morning. May it please the court, my name is Melissa Johnson. I'm an assistant district attorney in Middlesex County here on behalf of the Commonwealth. First, briefly, just to address the 16L letter that my brother sent about the Muckle case, I would just point out that the definition of witness is a bit more liberal than my brother would have this court believe. I believe the definition is the possibility that a target of the defendant's conduct will be called to testify in an official proceeding. Not that there actually is an official proceeding, so I don't think that Muckle intended to exclude what happened here. In any event, we still have a recourse, I suppose, in Superior Court. In any event, I'd like to go on and move on to the sentencing issues that my brother raised during argument. I will say, as far as Rule 28 was complied with here, because the judge gave both counsel and the defendant an opportunity to speak. So in terms of her right to speak under the rule, absolutely, and her counsel's, that was absolutely complied with. First, her counsel did a very convincing job because she ultimately got what she wanted as far as talking about her background, her employment, the fact that she's self-sufficient, she's a student. She did talk, the counsel did talk about the fact that this defendant was sorry for what happened that night. And then Judge Hogan gave this defendant the opportunity to speak, even though Rule 28 doesn't exactly require this. But
is there a constitutional right to allocution?
I don't believe so, Your Honor. And it's never been recognized by the Supreme Court or by this court. And although there is a federal rule that speaks to that, our rules have never adopted that. And it's interesting, I just filed a brief in the appeals court as far as Rule 12 pleas and the evolution vis-a-vis the federal rule. And I think that, I'm convinced that everything the Rules Committee does here is very deliberate. Now, Rule 28 here, I think the last time it was modified was in 2008 or 2009, after the federal rule, which does give or actually requires the federal judge to address the defendant. Doesn't necessarily require that the defendant speak, but just address the defendant to see if there's anything he would like to provide in terms of materials or his own voice. But we've never adopted that here in Massachusetts, and I think by design it's been that way, leaving it to the defendant and his counsel to figure out between the two of them, or both of them, how to present or how to put their best foot forward on this. Certainly there may be instances where a defendant may not do as good a job or may somehow countervail his attorney's attempts to present an argument in mitigation. And so I think that by design the Rules Committee has left it to the defendant and his attorney to figure that out, how to put that best foot forward.
Would you talk a little bit about the revocation of bail to get the defendant's attention?
Yes, I do believe specifically you're talking about a statement in the second part of the sentencing hearing in Volume 3 where the judge said that,
Yeah,
I
so she
trust that
revealed
I
that's
got
the
your
reason.
attention.
That's right.
I would say, Your Honor, that that was in direct response to what counsel had just argued. Counsel had just argued that being in custody these few days really opened the defendant's eyes. And so I think that was probably in direct response to that.
Well, I don't mean why she wanted to get the
Okay.
defendant's attention, whether that was proper, whether it was proper to revoke bail for that reason.
Oh, I see, I'm sorry. Your Honor, I do believe that this is in the discretion of the judge under Rule 28B. Rule 28B gives judges the discretion to either commit or to alter or reduce the bail or even put the defendant on probation at that point with conditions. So for that reason, it is discretionary. I'm not really sure why my brother is comparing the jurisprudence of the bail statutes and the bail and all of the jurisprudence that interprets those statutes, because those specifically protect the right of the defendant's liberty pre-trial. Before the Commonwealth has proven its case beyond a reasonable doubt, there are due process concerns, there are liberty concerns with incarcerating someone who hasn't yet been proven guilty.
So your position is the bail statutes have no applicability whatsoever once he's convicted?
Not the applicability that my brother would have.
So what is
believed.
their I mean, what is the judge doing when she's convicted?
She is convicted, a verdict of beyond a reasonable doubt has been rendered. At this point, the judge's attention is turned towards sentencing, has the right to sentence.
So is that but then you seem to be slipping into your brother's argument, which is that we've got two sentences here. We have the 4-day sentence and then we have the probationary sentence. Do you really want to go there?
Well, I would believe that at this point, the judge has more discretion on how and when they are going to have that defendant serve the sentence. So that all the issues.
So when the judge is doing this, she's not revoking bail, she's sentencing the defendant for 4 days? What is she doing? I'm just trying to understand what she's doing.
She's holding the defendant pending final imposition of sentence with the view to, if she is committed, those days will be credited to her final sentence.
But she doesn't do it that way. She doesn't say, my example, I'm sentencing you to 4 days, time served, and then probation. She says, I got your attention. Basically, I taught you a lesson, maybe, and now I'm going to give you probation.
Well, the interesting thing is had she actually honored the Commonwealth's recommendation of 90 days to serve, or even just 30 days to serve, I'm not sure that my brother's argument would have any weight. She would simply credit those 4 days.
Right.
And even if she had later violated probation, those 4 days would be credited. So I think I'd like to take a step back and at the first part of the statement.
Just so I understand, what are those 4 days? How do we describe those 4 days?
Those 4 days would be part of her sentence ultimately. Those would be credited to her sentence. Just like if she were held, and I do believe she was held when she was arraigned prior to posting bail for about a week, according to the docket. I believe she was held for 7 days. Those days would be credited to her sentence. So I think at this point, and I think as Chief Justice Cants pointed out, there usually, not always, usually is a little bit of a lag time between actual verdict and ultimately sentencing. And in this case, as in many cases, the judge did want to hear from the victims. Perhaps in a Superior Court case, there would be a pre-sentence report that would be drafted in the interim. And in this case, I just would point out that committed time was certainly on the table. We have a situation here where the facts of the case were fairly vicious. This defendant had basically walked in there. This couple was in a restaurant closing up. They had been there all day. They're just trying to close up. The defendant comes in, wants to use the bathroom, And 15 minutes later, the victim's husband is being carted off in an ambulance. There's absolutely no reason for this. Plus, given that she does have a history, that committed time was on the table. The judge knew that. Certainly by law, that was permitted. And so the Commonwealth at that point had asked for committed time. The judge was certainly considering committed time. It would have been reasonable, just taking a step back, for her to sentence this defendant to 4 days or 90 days, anything in between. But at the end of the day, she did decide that probation was appropriate. So the defendant did get what she wanted in the end of the day. And so it's not uncommon, as pointed out in my brother's argument, for a judge, especially in a case that involves violence such as this, for a judge simply to commit the defendant pending sentencing with the view that I'm probably going to commit this person, I'm seriously considering it, and then ultimately crediting that time to the committed sentence. Judge has to have discretion to do that, because ultimately sentencing is within the discretion of the trial judge, as long as it's commiserate with whatever maximum penalties are prescribed by law. So in that sense, there's nothing that the judge here did that would warrant, number one, resentencing, but certainly not a double jeopardy violation that would cause us to retry this entire case. Are there any further questions about that before I move on to ineffective assistance of counsel? Just quickly, I just want to point out, my brother had mentioned that certain promises were made in opening statement. I would just urge this panel to reread that, because there were no promises in opening statement that this defendant would testify or anything of that. In fact, the defense attorney said that their theory of the case was this defendant didn't touch.
Can I go backwards for a second? The same question I asked your brother. If we don't quite agree with you and we think the judge was, crossed the line when she said, I got your attention, is there a lesser remedy here that, it seems like you're both presenting us with an all or nothing. If we still think that was improper, you have any other suggestions on how to remedy that?
Your Honor, I think that honestly the best that the defendant can get here is a resentencing, and resentencing to exactly what she had asked for in the beginning, which is probation, which at this point she successfully completed. In fact, it was terminated early. So I really don't think beyond that one statement, which was essentially a repetition of what her counsel had just said, would warrant that. That remedy, but certainly not.
So you say we interpret this as just saying, I agree with your counsel that I've got your attention, I guess.
Well, I think that she was presented with a difficult
Even
situation.
even though before she does this, the defendant's begging her not to do it, right? I've got to work. I can't remember, the dialogue is pretty, I'm going to lose everything. I'm going to lose everything. Oh my God, Your Honor, I'll lose everything. So, and there's no back and forth on why we're doing these 4 days, right?
Right. There's not, I think, as I had pointed out before, the facts of the case certainly reasonably warranted some committed time, and that had to have been in the judge's head. But if you look at that transcript, she really is wanting to give this woman a break. She wanted to know all about her. She wanted to know her background, tell me about her. And she listened carefully to counsel. She listened carefully to the defendant. But when she started to, and the counsel had said she's very sorry for that. That was remorse that this judge wanted to credit. She wanted to credit her for that. But she couldn't once the defendant started to get into the facts of the case, and this is really, wasn't my fault, it wasn't my fault, I didn't do anything, they said this. At that point, the judge is, well, I wanted to credit that remorse to this defendant. I wanted to give her some mitigation for that, but now I can't. Now I'm back to considering committed time. So I think for this defendant, for this judge, she was considering carefully what to do with this defendant, I think if you read the transcript, she truly wanted to give her a break. And at the end of the day, she did give her a break, but at that point, what she was left with was a reasonable request for committed time, given the facts of the case and given her history. Does that answer your question, Justice Copper? And so just back to ineffective assistance very quickly. This defendant was able to advance the theory through the testimony of Officer Gallagher. I will also just caution that this so-called theory of defense of property is only applicable to the assault and battery conviction, not to the intimidation of a witness conviction. And so I don't really see it as a specific theory as far as doing away with the assault and battery, because in the end, her theory was that I hadn't made any contact with this particular defendant. But she was able to advance kind of a global theory of why things had escalated by kind of making up this whole debit card issue. I would say that this all goes back to the credibility of the affidavits that were submitted in support of the motion for new trial here. The trial judge, or the motion judge who was the trial judge, saw these affidavits, who were all, of course, mirror images of each other, and insinuating that there was some third party that magically appeared and viciously attacked the victim's husband. That presentation to this particular motion judge, who was the trial judge, she was entitled to discredit this entire theory that counsel had somehow been ineffective by not presenting this theory. For that reason, I ask this court to affirm the judgment against the defendant. Thank you.
Before we call the next case, I see that